opinion on the request submitted by the General Assembly of the United Nations on the question of the obligation of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. Judge Bandari, who attended the oral proceedings, could not participate in the deliberation and the vote on the advisory opinion. I note the presence of the representative of the many states and international organizations that have taken part in these proceedings. The question on which the advisory opinion of the Court has been requested is set forth in Resolution 79/232, adopted by the United Nations General Assembly on 19 December 2024. The question submitted to the Court read as follows, I quote, "What are the obligations of Israel as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations, and third states, in and in relation to the occupied Palestinian territory, including to ensure and facilitate the unhindered provision of urgently needed supplies essential to the survival of the Palestinian civilian population, as well as of basic services and humanitarian development assistance for the benefit of the Palestinian civilian population and in support of the Palestinian people's right to self-determination." End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 17. The full text of the opinion will, of course, be available at the close of the sitting. The Court first considers whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why it should, in the exercise of its discretion, decline to answer the request. The Court notes that by virtue of Article 96, Paragraph 1 of the Charter, the General Assembly may request the International Court of Justice to give an advisory opinion on any legal question. The Court considers that the question submitted to it is a legal question within the meaning of Article 96 of the Charter and Article 65 of the Statute. The Court concludes that it has jurisdiction to render an advisory opinion as requested by the General Assembly. Turning to discretion, the Court recalls that only compelling reasons may lead it to refuse to give its opinion in response to a request falling within its jurisdiction. The Court focuses on arguments that were either not addressed in its advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, to which I shall refer as the 2024 advisory opinion, or that arise from the distinct legal and factual context of the present proceedings. The Court first considers the argument that the question put to it is premised on allegations that are currently under consideration in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, and that giving the advisory opinion might prejudge elements relevant to that case. The Court does not find this argument convincing, as there is a clear difference between the respective subject matters of the two proceedings. In the present advisory case, the Court's mandate is limited to the identification of Israel's obligations as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. By contrast, the contentious case between South Africa and Israel concerns the question whether Israel has violated its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention. The distinction between the two proceedings is unaffected by the fact that the Court's orders indicating provisional measures in the contentious case direct Israel inter alia to ensure the provision of basic services and humanitarian assistance to the population in the Gaza Strip. The measures indicated seek to preserve certain rights that the Court found to be plausible under the Genocide Convention. Although the same conduct may be required of a state under different legal rules, and the same conduct may simultaneously breach multiple obligations, a determination made by the Court in the context of one obligation does not necessarily prejudge the question of compliance with a different obligation. Here, the facts that are relevant to a potential finding of a violation of obligations under the Genocide Convention are sufficiently distinct from the facts that are relevant to the determination of Israel's obligations as an occupying power and as a member of the United Nations in the present context. There are, however, factual and legal matters that may be relevant both in the present advisory proceedings and in contentious proceedings. In this respect, the Court recalls that the parties to pending contentious proceedings will have the opportunity to present evidence and arguments on questions of fact and law on the basis of which the Court will decide in those proceedings. The Court then turns to the argument that the question put to it has already been largely addressed in its previous advisory opinions on the legal consequences of the construction of a wall in the occupied Palestinian territory and on the 2024 advisory opinion. The Court considers that the current request differs from the earlier ones and concerns a question that was not addressed in the previous advisory opinions. First, the present request pertains to a specific issue that had not emerged at the time of the earlier advisory opinions. As recounted in the preamble of Resolution 79/232, the General Assembly's request was approved following Israel's adoption of legislation on 28 October 2024, curtailing the operations of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, UNRWA. Second, the 2024 advisory opinion was limited ratione temporis to policies and practices taking place before 7 October 2023. By contrast, the present request concerns conduct taking place after that date. The Court then examined the argument that the request would require it to undertake significant factual investigations and make findings on disputed and evolving matters which cannot properly be pursued in the framework of advisory proceedings. The Court notes that the case file contains ample documentation concerning the relevant facts. In the present case, the Court considers that the information available enables it to decide legal questions in a manner consistent with its judicial function. Finally, the Court rejects the argument that the request abuses and weaponizes the international judicial process. Even if allegation of abuse of process could be advanced in the context of advisory proceedings, the Court does not consider that there is any basis for such a finding in the present case. The Court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The Court then outlines the general context